Assalamualaikum and a very good day I bid to everyone. My name is Nisa Husna binti Kamal Bahari.
My name is Nur Shahira binti Jamaluddin.
Hello and Assalamualaikum. My name is Siti Khadijah binti Firdaus Fitri.
And today me and my teammates are going to briefly explain about the judiciary system in Malaysia. The hierarchy of courts of Malaysia starts with the Magistrates Court as the first level, followed by the Sessions Court, High Court, Court of Appeal and the Federal Court of Malaysia. The Federal Court of Malaysia is the highest court of the land. The Magistrates Court and the Court for Children and the Session Courts are the subordinate courts. The High Court, Court of Appeal and the Federal Court are superior courts. Outside the court hierarchy are the Sharia courts and the native courts. I will start off with the Federal Court. This court is the highest court and the final appellate court in Malaysia. Article 121 Clause 2 of the Federal Constitution establishes the Federal Court, which comprises the Chief Justice of the Federal Court, the President of the Court of Appeal, 2 Chief Judges of the High Courts, and 11 other judges. The jurisdiction for the Federal Court consists of 4, which is the appellate, which is this court has the jurisdiction to hear criminal and civil appeals from the Court of Appeal. Second one is original. This court exercises original jurisdiction on matters under Article 128, Clause 1 and 2 of the Federal Constitution. The third one is the referral. The court determines constitutional questions that arise in the high courts but were referred to the federal court for a decision. And the last one is advisory. Article 130 of the Federal Constitution states that the court can give its opinion on any question which has arisen or likely to arise and which has been referred to by the Yang di-Pertuan Agong concerning the effect of any provision of the Constitution. The Federal Court judges are appointed by the King on the advice of the Prime Minister, and all judges mandatorily retire at the age of 60. Every proceeding in the Federal Court shall be in accordance with Section 74 of the Courts of Judicature Act 1964. It shall be heard and disposed of by 3 judges or such greater uneven numbers of judges as the Chief Justice may in any particular case determines.
Court of Appeal is constituted under Article 121(1)(b) and the procedure to lodge an appeal is governed by the Rules of Court of Appeal 1994. This court consists of President of the Court of Appeal and 10 other judges. It has the jurisdiction to determine appeals from High Court or Judge or the federal law. Every proceeding composite 3 judges or greater uneven number per sitting in accordance with Section 74 of the Court of Judicature Act 1964. As most of us know, Court of Appeal is the second highest court below the Federal Court. It is an appellate court of the judiciary system that has the power to hear appeals against High Court related decisions regarding criminal matters. The principal registry of the Court of Appeal is located at the Palace of Justice in Putrajaya. Appellate jurisdiction in civil matters. Court of Appeal has the jurisdiction to hear appeals from any judgment or order of High Court in any civil matter, whether it was made on the exercise of original or appellate jurisdiction, Section 67 of Judicature Act 1964. However, Section 68 of the same Act put a restriction on the appeals and cannot be made in following situations. First, when the amount or value of the subject matter is less than 200,500 ringgit, except with the leave of the Court of Appeal. Secondly, the order or judgment made by the consent of the parties. Third, the judgment or order only relate to goods. Last, whereby any written law for the time being forced, the judge or order of the High Court expressly declared to be final. Furthermore, Court of Appeals has the jurisdiction to hear and determine any criminal appeal against a decision made by the High Court either in the exercise of the original or appellate revision. Article 122 AA states that the number of High Court judges in Malaya must not exceed 47, while in Sabah Sarawak must not exceed 10 courts.
High Court is constituted under Article 1211 of the Federal Constitution and Part 2 of Courts of Judicature Act 1964. 2 High Court having coordinate jurisdiction and status, namely the High Court in Malaya and the High Court in Sabah and Sarawak. The local jurisdiction of the High Court comprised the state in Malaya and the territories in Sabah and Sarawak. High Court also specifically hears cases of divorce and matrimonial cases for non-Muslim and admiralty matters. Here are three jurisdictions in High Court. First is original jurisdiction, which is civil matter. This court has unlimited criminal and civil power. Any civil matter which cannot be determined in the subordinate court will be heard before the High Court. Appellate jurisdiction. This court hears civil and criminal appeals from the magistrate and session court. Revisionary jurisdiction. This court has the power to refer any points of law arising in the appeal from the decision of the Court of Appeal if, in its opinion, it is of public interest and of paramount importance.
Next, I will move on to Session Court. This court is preceded by a Session Court judge. The jurisdiction under Sessions Court in terms of criminal is that Sessions Court shall have jurisdiction to try all offences other than offences punishable by death. Section 63 of the SCA, which is the Subordinate Court Act. A session court may pass any sentence allowed by law other than the death sentence. Section 64 of the SCA. Next, the jurisdiction under civil. According to Section 65 of the SCA, a session court shall have jurisdiction for the following matters. The first one, unlimited jurisdiction to try all action and suits of a civil nature in respect of motor vehicle accidents, landlord and tenants, and distress. The second one, jurisdiction to try all action and suits of civil nature where the amount in dispute or the value of the subject matter does not exceed 1 million ringgit Malaysia. And the last one, jurisdiction to try all action and suits of a civil nature for a specific performance, as well as the cancellation or ratification of instruments.
Magistrates Court is the subordinate court in Peninsular Malaysia as stated in S32 of the Subordinate Act 1948. The court deals with civil and criminal cases and is presided by the magistrate. Magistrates is classified into two classes, which are the first and second class magistrates. Most of the magistrate courts only have original jurisdiction. First class magistrate regarding the federal territory is appointed by Yang di-Pertuan Agong on the recommendation of the chief judge. Regarding to each state, first class magistrate is appointed by the state authorities, also on the recommendation of chief judge. According to Section 78 Subordinate Courts Act 1948, first class magistrate are the public servants of the Federation, Article 132 of the Federal Constitution, and it has two types of jurisdictions. In criminal matters, the court has jurisdiction to try the criminal offences which carry the maximum term of imprisonment not exceeding 10 years, or punishable with fines only, or are under Section 392, robbery, and the 457 of the Penal Code, trespassing and housebreaking, according to Section 85 of the Subordinate Court Act 1948. Nevertheless, a first-class magistrate may pass any sentence by law not exceeding 5 years of imprisonment, a fine of 10,000 ringgit, whipping exceeding 12 strokes, or any combination of the above under Section 87 of the Subordinate Courts Act 1948. Whereas for the civil jurisdiction, the first-class magistrate has the jurisdiction to hear and suits of a civil nature where the amount of dispute or value being claimed under the civil cases must not exceed 100,000 ringgit Malaysia under section of the SCA Act 92. Now we have come to the second class of magistrate court. The second class magistrate for both federal and state authorities are appointed by Yang di-Pertuan Agong. It also has two types of jurisdiction. Firstly is criminal jurisdiction, where the second class magistrate courts has a jurisdiction to hear cases which have a term of imprisonment not exceeding 12 months or punishable with fine. A second class magistrate is allowed by law to impose a sentence up to 6 months of imprisonment, a fine not more than 1,000 ringgit, or a combination of both sentences. And if a conviction exceeds his power and the sentence is inadequate, he shall adjourn the case to a first-class magistrate. On the other hand, civil jurisdiction of a second-class magistrate only has jurisdiction to hear any action or civil suits where the amount plaintiff seeks to recover to a debt or liquidated a demand in money payable by the defendant not exceeding 10,000 ringgit with or without interest. according to Section 89 of the Subordinate Court Act 1948. For the purposes of small claims, according to Order 93 Rules of Court 2012, any small claims other than debt, such as damages, which applies to claims with a value of 5,000 ringgit and below, where you must be prepared to conduct the case yourself as legal representation is prohibited.
Court for Children. It was established under Part 4 of the Child Act 2001. The purpose of having the Court of Child is to hear, determines or dispose any charge against a child. The court consists of a first-class magistrate and assisted by 2 advisors, and one of the advisors must be a woman. Function of advisor is to inform and advise the court on any consideration affecting the mood upon a finding of guilty or other related treatment of a child brought before it. The court has the jurisdiction to try all offences punishable except offences punishable with death penalty. For offences punishable with death penalty, for example murder, the case will be heard before the High Court and not the Court of Children, because Child Court has no jurisdiction to hear the case in like Section 97 of the Child Court Act 2001. If the child offender is found guilty, he will be detained in a prison under such condition as the YDPA or Yang di-Pertua Negeri may direct. Once the Court of Children is satisfied that a child has committed an offence, the magistrate preceding the court may impose a sentence from Section 9 of the Child Act 2001. Court for Children should avoid dispensing the imprisonment sentence if the child can be suitably dealt with in other ways, such as probation order, where the child will be placed under the supervision of a probation officer for a specified period, fine or being sent to a place of detention or approved school such as Hendry School for 3 years until age 21.
I have mentioned the court outside the court hierarchy, which are the Sharia courts and native courts. I will start off with native courts. Native courts only exist in Sabah and Sarawak. The courts have the jurisdiction to decide matters pertaining to native laws and customs. The parties to the proceeding must be natives. The natives of Sabah and Sarawak are inheritors of a rich oral tradition that was passed down through the ages. It eventually crystallized into a set of rules which regulated and maintained order and social relationship. The arrival of British rule in Sabah and Sarawak transformed the native customary laws from being an oral tradition to a set of clearly defined written rules and legal framework. Next one is Sharia court. Sharia courts, which consists of Sharia law, which only applies to Muslims. Sharia court's jurisdiction for Islamic offences: jail maximum 3 years, fine maximum 5,000 ringgit Malaysia, and 6 whips maximum. Constitutionally, Sharia courts have no jurisdiction over Islamic offences unless authorized by the federal law.
So to conclude, judges are given the power to interpret and execute the law with the authority vested in them. The judiciary is a body of judges in a constitutional system. There are 5 courts that are divided into 2 sections, which are the Superior Court, which consists of Federal Court, Court of Appeal, as well as the High Court. The second section is the Subordinate Courts, which involve the Session Court and Magistrate Court. Through the Constitution, each branches of the government is protected and prevented from the misuse of power. And lastly, each court have their own power. And that is all from us. Thank you.